All right, so we're gonna start off working with going over this trust situation, contracts, all different type of things. We're just gonna try to pull this together, and we're gonna get somewhere. Where? I don't know. All right, so Cestui Que Vie, right? So by that definition, this is what they have. You can read that right there. So it's a legal term for an individual who is the beneficiary of a trust or an insurance policy with rights to property and the income and profits that the property provides. Cestui Que Trust is the person entitled to an equitable rather than legal trust in the estate's assets. Okay. So let's get into that for a minute. So pretty much everybody knows you have a lot of these things in your everyday life, trust, insurance policies. Yeah, so we could say a deed of trust or an insurance policy, which you have, you know, for a car or whatever, title insurance, um, homeowners insurance. So this is telling you in these things, the individual who is the beneficiary of these things is who, right? So that's the key question. Now, the concept is also used in modern life and health insurance policies. See? So you will be that beneficiary then. So you will be that Cestui Que Vie, right? He who lives, right? If you got limbs, you're living. Paperwork, corporations don't live, right? So where Cestui Que Vie is an individual whose life measures the duration of the insurance contract. Okay. So right here, they're saying they're measuring the duration, right, of your life, right? So they're measuring your life and it's covered throughout the duration of the insurance contract. Okay. These contracts, Cestui Que Vie is known as the policyholder, insured, or policy owner. Thus, while the term refers to the beneficiary of a trust or estate, it often refers to the insured and not the beneficiary of an insurance policy. So this is telling you right here that in any policy or trust that is created, which is all the time, that you are the beneficiary of that. So the reason why I use certificate of live birth as an example, because this certificate of live birth is created at your birth. And if we, okay, so as we went from the certificate of live birth, right, I want to come here to a definition. This is 9-102, the Uniform Commercial Code. So we're going to come down here to certificate of title, right? So you see it right here, certificate of title. So it says a certificate of title with respect to which a statute provides for the security interest in question to be indicated on the certificate as a condition or result of the security interest obtaining priority over the rights of a lien creditor with respect to the collateral. The term includes another record maintained as an alternative to a certificate of title by the governmental unit that issues certificates of title. If a statute permits the security interest in question to be indicated on the record as a condition or result of the security interest obtaining priority over the rights of a lien creditor with respect to the collateral. So, certificate title is with respect to which a statute provides for the security interest in question be indicated on a certificate. So, as we know, when you got your birth certificate, it's going to say certificate of live birth. You compare that to a certificate of title that you have, for an automobile, right? So um, that gives you an example. They look identical. Now, we're going to go over here to this communication in regards to donor donee, right? Just a simple conversation I had, right? But first, what we're going to do is we're going to go over here to this definition, right? So here's a donor. Okay, the party conferring a power, one who makes a gift, one who creates a trust. He gives lands or tenements to another entail. So a lot of people think a donor is just something that is just you're just donating something like giving it away for free, but actually it has a lot more power um, than what the common definition is, right? So we go up here, we see what a donee is. So on the opposite side, one to whom a gift is made or a bequest given, one who is invested with the power of appointment. Okay, so the appointment, the party executing the power. So that's what you have in regards to that. There's other ones, donee beneficiary, right? And that's what a lot of these things are. A lot of these contracts that you get in are third party contracts by these servicers. That's a whole nother conversation. So you got donee beneficiary, you got donee of power, right? This donee of power, people think that they're the ones with the power. No, they're the ones that have been appointed power to do such a thing, right? So right here it says the person to whom the settlor or donor of a power of appointment gives such power to be exercised in the case of a special power in favor, so on and so forth. So now just I had some conversations about this, questions, and this is some of the stuff I came up with. Um, so you guys can take a look, blow it up a little bit, right? So you see some of these sources here, right? Where we get to talking about these obligee obligor situation, right? All this is based off the gift, a donor donee relationship, and what we call the ors versus the e's. Let's just put a apostrophe there. This is what you have everywhere. You have trustor, trustee, grantor, grantee, mortgagor, mortgagor, so on and so forth. All right. So let's take a look at this. So first we're going to break down clearly and then related to deeds of trust, mortgage, REITs, and REMICs, right? REITs are real estate investment trusts and REMICs are real estate mortgage investment conduits. Plain English breakdown of the passage, right? Some older or generational dictionaries incorrectly define the word obligee in a way that confuses it with obligor. Usually in there, they say you're the obligor, meaning you're the one obligated to do something. Obligee is the one that is receiving or the one that can enforce the obligation. Let's see what this say. Okay, so examples of the mistake. Random House College Dictionary says an obligee is a person who is under obligation. But definition actually describes an obligor. Okay. An obligor is the one who owes a duty or obligation. An obligee is the one to whom the obligation is owed, i.e., the creditor or beneficiary. And that is wrong. This is right. See, Random House College Dictionary, right? Okay. So you see right here, Random House College Dictionary, 1988, and Webster New World Dictionary, 1979, define obligee in its etymological sense, obliged, as if it were synonymous with obligor. Random House, for example, defines obligee as a person who is under obligation, but that meaning ought to be reserved for obligor. An obligee in modern usage is one to whom an obligation is owed. See, this is how they flipped it around. The obligee is the one that is the one obliged. They have the obligation. How can an obligee not have the obligation, but at the same time, the trustee has an obligation, has a fiduciary responsibility, right? So it just as I showed you in a donor donee situation, a donee is to who a gift is made or bequest given. A donee of power is the person to whom the settlor or donor of power of appointment gives such power to be exercised. That's the donee, one who is invested with a power of appointment. Okay. And the donor is the one that creates the trust, right? So these are the usages that they're doing these days to confuse the situation. So this is the modern usage. An obligor is the one who owes a duty or obligation. So an obligee is the one to whom the obligation is owed, i.e., the creditor or beneficiary. Now, an obligee in modern usage, right? But before, it was different. So the obligee is the one that's actually transferring the trust in a way where it gets tricky, right? So we come back over here to this right here to the Cestui Que Vie area. We're going to go down here and we're going to let's go here. So in trust law, beneficiary or Cestui Que is the person or persons who are entitled to benefit of any trust arrangement. Beneficiary will normally be a natural person, but it is perfectly possible to have a company as the beneficiary of a trust. And this also often happens in sophisticated commercial transactions structures, like a deed of trust, right? So where a trust gives rise to sequential interest from a tax perspective, it is often necessary to differentiate beneficiaries sequentially between those with invested interests, such as tenants for life, okay, and for the purpose of various exercise of beneficiary rights. So this right here is the main thing. So for the purpose of various exercise of beneficiary, it's often necessary to distinguish between beneficiaries under a bare trust, including a constructive or resulting trust, to whom the trustee owes basic duties arising by law, and beneficiaries under an express trust with an inter vivos trust or a testamentary trust where the trustees owes additional duties and has additional powers specified by the trust instrument. So if the trustee owes basic duties, then how is the obligee owed money? So if the trustee is owed basic duties and they have to follow these duties and these powers, as I mentioned in the donor, then why is the obligee different, right? So that obligee still has a fiduciary duty. They are a servicer, and they're supposed to be receiving any funds, whether it is on behalf of the beneficiary, which is who, right here. See, this is how you know these contracts are being modified during the transaction, where it's already been done. So when you receive the thing and you receive any type of certificate, that is showing that you have rights and interests in that thing, and it has been paid in full. Just like a grant deed, a grantee says on there, it says specifically that you um for good and value consideration, right? That's what it says. For good and valuable consideration, that means it was paid. The seller or the previous owner had the property, had the land, and then granted it to you under a color of title. It's still a color of title, but it showed that there was consideration that was transferred to that individual, and you got the thing. Now, this deed of trust and these other instruments that they're doing behind that is an encumbrance to cloud title, so that way they can have what again? Tenements, right? You want to look up what a tenement is? I just need a quick definition. That's it. See, tenement house, apartment, flat, a house used as a dwelling, a residence, right? Any of various forms of corporeal property, such as lands or incorporeal property that is held by one person from another. Okay, so when we give them tenement, that means we're giving them resident in our estate, but it is to be done from a donor, donee, trust or trustee position that you have the power of under that Cestui Que Vie. Okay, so so this part is very important. Now, when we get down to this right here, right? So this is corporate juris secundum, some notes. It talks about intention of creator or settlor, right? So this creation, right? Because you created a trust, right? By the donor's definition, right? Violation of intent, substitution of discretion, neither court nor beneficiary, not legislature, is competent to violate settlor's intent and substitute its discretion for that of settlor. Okay. So whatever your intent is not to be violated. And if the intent is to create a trust through the donor donee relationship, through the gift, then that is what it is. So that's a resulting trust. A resulting trust is like an implied trust. It's set up in a way to where it hasn't been fully expressed what your intent is. So that's why when you get down here to you got you got deposits for specific purposes, right? And then you have, where is it at? Okay, banks and banking, right? So when you get into banks and banking, this is where you get into your special deposits, right? So this explains it. Special deposit is a delivery of property, securities, or even money to the bank The purpose of having the same safely kept and identical thing deposited, returned to the depositor, or one for some specific purpose, such as deposits discussed. Not contemplating that credit on general account may also be defined as one held for a particular purpose in identical or equivalent form as when deposited, subject to return at any time and no commingled by the depository with other funds or assets of the bank. A special deposit is the deliverer of either money or chattel to a bank under a special agreement or under circumstances sufficient to create a trust, right? One who creates a trust. All right. Or a deposit accompanied by agreement that the identical will be returned or paid out for a specific purpose, or a bailment, agency, or trust, whereby a bank keeps or transmits the identical property or funds entrusted to it. So there we go. So everything that you're doing, regardless, under the system that is today, you're setting up a trust. Everything that happened from the beginning was all set up under trust, in which they have figured out how to circumvent that in order to get access to your estate under a servicer as a servicer, and then be able to claim a beneficiary to your estate. If you look at your deed of trust, your trustor, trustee, beneficiary the bank is gonna be the beneficiary. How is that? You gotta ask yourself that question. In this area right here, we have um, banks and banking, special or trust deposits. This is where I want to start off with. Um, right, so a deposit of public funds may be entitled to priority without regard to whether there is a prerogative or statutory right of preference in favor, where the circumstances are such as to render it a special or trust deposit. Right, so if you make it a special deposit, it is a trust deposit. That's why I'm saying or. Right, either or. You can use either or. In the absence of sufficient special circumstances, however, a deposit of public funds, like a deposit of other monies, create merely a general deposit, right? So, in the absence of sufficient special circumstances, so you didn't express you want a special deposit or trust deposit. A deposit of public funds, like a deposit of other monies, creates merely a general deposit, giving rise to the relation of debtor and creditor. And the mere fact that all public monies are, broadly speaking, trust funds or held in trust by the officer depositing them does not of itself render a deposit of such funds a special or trust deposit so as to entitle it to priority. So even in this situation, you're still the creditor, right? Relationship between bank and banker. Okay. So this is going to let you know what your relationship is based on your deposit. There is no debtor and creditor relation between the bank in which special deposit is made and its special depositor, their status or relation being that of agent and principal, bailee, bailor, or trustee and Cestui Que Trust. Okay. Title to the thing deposit does not pass to the bank but remains in the depositor, the latter retaining the right of control and disposition. Thus, the depositor retains title to the thing deposited, and the bank acts as a bailee, right? So, if the bailee is in the same position as a trustee and an agent, then as an obligee, why would he be any different than a bailee, trustee, or agent, right? So, this is what you have. So now when we go back over here to Cestui Que Vie, right? So we know what the Cestui Que Vie is. Now, he who lives. He's the donor. He's the beneficiary, right? So we have insurance policies, trusts, right? You have all these aspects now. Now we could bring it back in order where we can actually see what the Cestui Que Vie is talking about. Only way you're going to be a Cestui Que Vie is if you function as a donor, right? With the power of appointment and make sure you create that trust. Because if you don't create that trust, as is defined here, then basically what you're doing is you're creating a resulting trust. The resulting trust now, the donee can take it and utilize it to what he might assume that you want. And usually they're going to do that to their benefit. Okay. So there we go. Now let's go back to this donor donee situation, right? So now we know that an obligee is the one who owes a duty or obligation, not the obligor, right? So you got a grantor, grantee, trustor, trustee, all the ors and e's, mortgagor, mortgagee, right? So let's come down here. So here's your deeds of trust. Three parties are involved: the trustor, borrower, and then they're the obligor. You see, the beneficiary, lender, the obligee. And then the trustee holds legal title and trust until the obligation is fulfilled, right? So now you see that this trust relationship is dysfunctional. It's out of pocket because if the lender is considered to be the servicer of the loan, and they'll tell you if you ask them, and why are they in a position of beneficiary when they never gave any type of consideration and they're not an heir to the trustor? And why is the trustee just holds legal title and trust under the obligation until the obligation is fulfilled? So that just it means that these two are working with each other against the trustor, who's the one that created the trust through their endorsement, right? But see, that's the issue. The trustor always usually endorses it in blank and does not do this or this. You see, that's that special deposit. Make sure you do it and given specific instructions so you create that trust, right? And it's usually done for the simple fact that they actually rush you in these matters. You know, they rushing you, sign here, initial here, initial here. They're not explaining to you what's going on. So it's moving so fast, more or less, you're probably excited because you bought the house and you getting a new car or something like so on and so forth, that you're not really paying attention to the deal that's actually being done. And that is a modification of things that has actually been completed. Because everybody say, I closed escrow. So if escrow is closed, why is escrow still open? You can see it on your bill. Now, okay, so uh, let's go down here. Okay. So the trustor, mortgagor, grantor, obligor is fundamentally acting as a donor, one who originates the power, value, or asset. So if that's the case, why is it why is the obligor, all these ors, are they the ones they're originating the power to get these things done, the value and the asset and or the asset, and why are they the ones that are considered to be the debtor, the borrower, and the one obligated for all the responsibility. And at the end of the day, still never receives nothing of value. and that this act creates fiduciary obligations for the recipients. And those are the E's, such as trustee, mortgagee, beneficiary E, or servicer, right? Okay, so let's analyze the theory step by step and consider its legal and strategic implications. Okay. Trustor, grantor, mortgagor is donor. The trustor creates the trust, granting legal title to the trustee for the benefit of the beneficiary. The grantor conveys property via deed. The mortgagor signs a mortgage or deed of trust to secure repayment. The obligor incurs an obligation, typically under a promissory note. These are all roles in which a person voluntarily conveys something of value, property rights, or obligation. The act is donative in nature, especially when done without full reciprocal benefit, or when done under power of agency. Positions the trustor, grantor, etc., not just as debtor, but as the originating party, akin to a donor or settler who delegates power and value, and whose intent and authority frame the entire legal structure. Now let's deal with the E parties as fiduciaries. Mortgagee, lender, receives the security interest. Trustee holds legal title in trust and has duties of loyalty and partiality. Beneficiary receives the benefit of the trust, often the lender or note holder. Servicer manages the loan on behalf of the investor/trust. These E roles imply fiduciary responsibilities because they are entrusted with value created or initiated by the donor/trustor. Duty of care, duty of loyalty, duty of accounting. Many trust laws, fiduciary duties flow from the one granting the power to the one exercising it. So you are shifting the framing debtor lender to donor fiduciary, which introduces equitable oversight and accountability. So when you utilize these terms, this debtor lender situation is out the window. So you use them for what it says they are: trustor, trustee, beneficiary. So for all these things, there should be value or some investment or some money coming back for that situation. So once you put them in their fiduciary capacity, they no longer can have tenement or lien or trespass into what is considered to be yours or beneficial to you as the Cestui Que Vie, right? Because we have a certificate of title that shows, which is a certificate of live birth that shows that there is a Cestui Que Vie in order, and you're the beneficiary of that. Because you cannot get anything if you don't have a date of birth and a social security number, right? So those things are the ones within the government system that identify you through the Fed. So that creation of that trust is under the power of a go here. Hold on.